Well, lockdown level 3 and 4 regulations are invalid and unconstitutional. That's the ruling made by the High Court in Pretoria after Liberty Fighters Network took government to court. Now, the court has ordered that Cabinet review, amend and republish the regulations. And to help us make sense of that particular judgment, we're joined by constitutional law expert Pierre de Vos. Prof, good morning to you and thanks for your time. This judgment comes at a fractious time in the life of the coronavirus in the country. I want to start off with your assessment of whether or not this was a carefully considered judgment.
Well, the judgment makes some good points about the way in which the regulations throughout the whole period of the disaster have been framed, and not the starting point not being to try and protect people's rights as much as possible and so on. But when it comes to the declaration of almost all the regulations as invalid and unconstitutional, it is a very broad and sweeping judgment that is not really justified by the law, because if you're going to declare something invalid, you have to look at that specific regulation, ask whether it's rationally related to the purpose of expressing the spread of the virus, and then make a decision on it. The judge just used a few examples and then declared almost all the regulations invalid. That is not really something that will stand up on appeal if the judgment is appealed.
All right, so what does that mean then if it is appealed? Is there a possibility that all of this could be overturned?
Yes, so we will first see if there is an appeal, because the government really has 14 days, because the judge suspended the order of invalidity for 14 days, so the regulations are still in place. If in the 14 days they appeal, then that will automatically suspend the judgment and the regulations will also be in place. And on appeal, I think parts or most of the judgment could be overturned because of the legal technical manner in which the arguments were phrased, and as I said, two sweeping rulings made in the judgment.
Yeah. Prof, the judge had some choice words for the Minister of Cooperative Governance, including her Director General, and in specifics, I'm talking about the answering affidavit that the judge cited here, saying that it made generalized statements about the circumstances, the special circumstances that led to the declaration of the Disaster Management Act. I want to ask of you the question: what does this do to the credibility of the minister?
Yes, so if you read the judgment and read a little bit between the lines, it doesn't look like the government lawyers took this case very seriously. They thought it was probably done by some fly-by-night people and it was never going to fly. So the responses were not good. But there's a bigger issue, and that is that the government and the minister specifically has been criticized consistently for not providing proper justifications for various of the regulations. So this is not something that happened only now with this court. It has come from the beginning, where some regulations are made on the face of it, they don't look particularly clear or rational, or we don't know what the reason is. And the government hasn't really given very good answers for that. So I think this judgment confirms that kind of criticism. But it's not criticism that hasn't been raised before. There's been one of the things for me that is interesting of the judgment is where the judge said the attitude of the government that they can use any means necessary to deal with the virus is the wrong attitude. They should have, we want to deal with the virus as effectively as possible, but always remembering that people's rights should not be limited unless it's absolutely necessary.
Yeah. Prof, also something I picked up that was quite interesting reading that judgment was that the Minister of COCTA, the insinuation almost being made that she could have misled or misrepresented the facts when she told the court that there existed no legislation by which Cabinet could deal with the coronavirus, and a piece of legislation is pointed to that is called the International Health Regulations Act.
Yeah. Yes, so the Disaster Management Act, firstly to say that the court didn't base its judgment on this. It was a kind of remark made that is not part of the actual binding reasoning of the court. But the Disaster Management Act says you can use this act if there's no other act available, whether it's the Health Act or these regulations that you are talking about. And it was clearly not before the court. So from the judgment itself, it's very difficult to evaluate whether that claim is true or not. I haven't had time to actually go and look at those specific regulations to see if it's the case. The bigger problem is when this happened, the government had to decide how they're going to deal with it. So on the one hand, they could have a state of emergency. They can use the Disaster Management Act or some other provision. I think that usually, unless there's clearly a problem, it would usually be for the government to make these kind of policy choices, and normally a court will not interfere with it unless it is clearly wrong on the law.
All right, Professor Pierre de Vos, thank you very much for your insights.